We need to get into the presentation, and today we have Eric Hanscom. He is a trademark patent attorney. Yay! So we want to turn everything over to him, and I will make him co-host, which if I haven't already. And Eric, thank you for joining us.
No problem.
There you are.
All right. Okay. Well, great. Thank you for attending. I really appreciate that. All the materials I'm presenting today will be available online. I know that Desi is trying to set up a link and you can just email me directly. I'll put my email contact information in the chat box. So everything you see today, you will be able to get online if you happen to have any questions about it. So anyway, I've been an attorney since the 1990s, and I've been doing intellectual property law the vast majority of that time, a little over 20 years now. And so today I'm going to be talking about trademarks, specifically how trademarks in the drone industry come together. And I'm going to share my screen right now. Could somebody let me know if you see droning on and on about trademarks?
Yep.
Yep, you're good.
Okay.
We see it.
Okay, great. All right. So trademarks are just one type of intellectual property. And I'm going to start by going over the three types of intellectual property, just because there's often a lot of confusion at the beginning about what is what. So intellectual property can basically be broken down into three sections: patents, trademarks, and copyrights. There's also trade secrets, but that's, another class. A patent is basically protection on ideas. Trademarks are protection on names. Copyrights are protection on art. And so a patent is actually an exclusionary right. It gives you the right to keep other people from copying your inventions. And we have patent law because if you couldn't protect your inventions, why bother being an inventor? Why bother being a scientist or having an R&D department? Trademarks, on the other hand, protect a brand identity. And the goal of trademark law is twofold. First of all, it tells consumers whose products they're buying. And the second thing is it gives people who make a product kind of an inherent desire to make a good product because they're going to be held accountable for it. Copyrights protect artwork, and there's copyright law because if there wasn't copyright law, there'd really be no reason to be an artist if everyone could just copy your stuff whenever they wanted. Let me just give you a few examples here. With utility patents, the goal is to protect the function of an item. So this is a patent we got for O'Neill on a new type of surfing trunk. If you look at the picture, it's got a stretchy band down the side, and this surfing trunk, it's called the Super Freak, actually managed to stretch and bend in a way that previous ones didn't. So it was the function of the item that was important. On the other hand, a design patent protects the shape. So this is the rattlesnake mug on the Craig Ferguson show. And obviously we can't get a utility patent on the function of something with round sides and a bottom that holds liquid because that's been done, since pre-Viking era. But you can get a design patent on the particular shape of the mug. So utility patents, again, protect the function of an item. Design patents protect the shape. Copyrights protect artistic content. And for you drone photographers and people in the drone business, this obviously is your drone photographs, your videos, your websites, any packaging, if you happen to sell products, your owner's material, your owner's manuals, any trade show materials, things like that. Now, a lot of people there are a lot of urban legends in intellectual property. One of them is, well, I get a strong copyright just by creating something. Well, you get a copyright, but if you get a registered copyright with the Library of Congress, you can sue somebody who infringes your copyright under a theory called statutory damages that allows you to ask for $150,000 for a knowing and willful infringement. And back when I used to do litigation, we had a couple of cases we settled out in the $60,000 range. One for a guy who copied one sentence off one of my client's websites. I had that one on contingency. That was a fun one. And another one where somebody copied my client's packaging and had it at a trade show for one day. And so, you really start seeing some major bucks for infringement if you get a registered copyright. If you don't have a copyright, you still have common law copyright rights, and you can go to court. You can prove how much you lost and how much the other side gained. It's called unjust enrichment, but basically it's kind of a will you please stop copying my picture, pretty please, with sugar on top? There's really not much you can do about it. So this is an example. This is one of my drone photographs. And I think you probably all know how to do Google image search and see who's stealing your stuff. This showed up on a Polish dive site. If it was in the US, I'd do something about it, but I can't do anything in Poland. So I didn't even bother writing this guy a letter. But if they're in the United States, it would have been a different matter. Okay, so let's get to what we're talking about today is trademarks. Now, the first thing about trademarks is, why should you bother getting one? Well, let's look at the evolution of a business. When you start out, if you're a drone photographer, if you're somebody who does inspections with drones, if you do real estate photography, if you sell your business a month after you start it, what's the value? Well, it's your drones, maybe your client list, maybe you can teach somebody how to fly specific routes, but the value really is in the people and what you own. Now, with a company that develops drones, develops products, eventually, hopefully you get some patents, and then the most valuable asset within your company is going to be your patents. But over time, the goal is, no matter what kind of a business you have, is to develop the business so much that the name of the business is its most valuable asset. And so if you're going to end up with a business that is either going to be franchised or sold or whatever, it's really worth your time to develop a good name for it. So if you're going to do this, why don't you do this from the start correctly? And if you don't believe me, maybe you'll believe Forbes. This is a chart that Forbes came out with a few years ago that evaluated the top 10 trademarks and compared them to the market cap value. Market cap is a way that you can estimate the value of a company. And so you've got the value of the trademark compared with the market cap value as a percentage. And if you notice here, Google, over a quarter of the value of the company of Google is its trademark, just its name. The property it owns, the software technology patents it owns, they're not as valuable as the name. Now, so you can see that if you develop a name and you protect the name, that it goes with the company, gives it a whole lot of value. When you look at here, you may look, there's kind of one outlier here, and that's Apple computers, where the Apple trademark is estimated to be only worth 10% of the value of the company. That's because Apple is such a technologically innovative company that it still has a lot of the value in its patents. But if you look to something like Walmart, Walmart doesn't have a whole lot of patents, but it does have a very strong trademark. Why bother getting a trademark too? Well, the first thing is that until you get a registered trademark, you really don't know if you're going to be able to use the name as the name of your product or the name of your company in commerce. And so it's kind of like permission to use the name. Many years ago, I made the mistake of offering for one of our chambers of commerce to do a free trademark search for all the members at a public forum. And I had two people leaving almost in tears because they owned restaurants and they'd been building up their brand for 10 or 15 years. When we did the trademark search, we found that somebody already owned the name. And so my advice to them was, well, sorry, I think you have to change your name. And they were like, I put 15 years of my life into this. So if you get a trademark, then it's permission to use the name. The second reason it makes sense to get a trademark is that if somebody accuses you of trademark infringement, that is, they say, hey, man, you're using a name that's way too close to my name. If you have a registered trademark, that's the best first line of defense, where you say, hey, your problem's not with me, your problem's with the US Patent and Trademark Office because they gave me the trademark. So you need to file what's called a petition to cancel my trademark with the US Patent and Trademark Office. And if you have your trademark survive for 5 years, you can file something called a declaration of incontestability that makes it basically impossible to challenge your trademark, except for a very, very narrow range of issues. So generally, you get your trademark, wait 5 years, make it incontestable. And at that point, you're pretty much home free. All right, what are some normal things that can be trademarked? Well, commonly, you've got things like names of companies, names of products, logos, slogans. So we've got a couple things, the Windows logo, the name Microsoft, and the McDonald's slogan, I'm loving it. McDonald's, by the way, they trademark, you see underneath their sign, it says over 1 billion served, over 60 billion served. They trademark each one of those. So Carl's Jr., even if they sell 55 billion hamburgers, they can't say Carl's Jr. over 55 billion served because Wendy's or McDonald's already owns all the trademarks that say over so many have been served. So these are the normal things that can be trademarked. You can also trademark a whole bunch of really funky stuff. So if you happen to be walking through a NASCAR race and you're walking near a car, you get a little whiff of the bearing grease and it smells like cherry. Well, the cherry scent of racing vehicle lubricants has been trademarked. So, okay, whatever. Lucasfilms has trademarked the sound of a lightsaber. And more recently, both Tim Tebow and Colin Kaepernick, neither of whom I believe are still playing football, but they are selling t-shirts under the trademarks Tebowing and Kaepernicking. So you can trademark a bunch of really weird stuff as well. All right, there's state and federal trademarks. Each state has a state trademark, and then there's also a federal trademark. Now, when I began being an attorney in the 1990s, we all knew there's this thing called the internet, and most of us started using email. None of us had websites. And so the way you got business was you rented an office on the walk from the parking lot to the courthouse, hoping people would walk by your office and give you business. And then you joined like the Lions Club, the Rotary Club. You had a threefold brochure that you handed out. That was how you got business. Well, the World Wide Web has kind of put that all to shame. So in the 1990s, state trademarks were really the best way to go because rarely were you doing business outside of your state. Now, with the internet, you're pretty much, the minute you put up a web page, you're doing business across the entire world. So federal trademarks right now are much stronger than state trademarks. However, I always try to get a couple of state trademarks for me personally, just because they give you some state law rights. And if you decide to bring a lawsuit in state court instead of federal court, trademarks are federal trademarks are federal law, state trademarks are state law. It gives you some advantages there. The other reason that you probably want to go with a federal trademark as opposed to a state trademark is that if you want to ever franchise out, it would be a real bummer if you got a state trademark on your name in California, somebody else got a federal trademark on the same name, and then you decided that you wanted to franchise to a couple of other states. Well, the federal trademark can end up kind of geographically restricting you to California. So again, federal is usually the best way to go. Now, that being said, some states have extremely lax standards for allowing trademarks. In the U.S. Patent and Trademark Office, which handles federal trademarks, it usually takes about 4 months just to have your trademark application examined. In Utah, a Utah state trademark, I filed those on Friday, and I've been notified on Sunday that the trademark was approved. So somebody's working weekends. So it's like, okay, that's an easy one. Arizona is another pretty quick turnaround. All right, what makes for a good trademark name? If you don't get anything else out of today, this slide is something I hope you remember. So the best trademark names are fanciful ones. These are words that are just made up. It's like Google, Kodak, Exxon. These words weren't made up until the companies decided to make them up. Now, these are in dark green because they make for usually a very cheap application for the client, because how can the U.S. Patent and Trademark Office examiner find trademarks that are close to a name that's just made up? Take Kodak. What's close to Kodak? The Kodiak Island, Kodiak Bear? I don't know. But these ones tend to go right through. Now, the problem with a fanciful name, obviously, is you need to build up the market for it so there's brand recognition. All right. Next in line, we have arbitrary names. You notice this is a little lighter green. These are not quite as sure of a thing. Now, an arbitrary name is a name that's well known in the English language, but is not commonly associated with these goods. So, an example here is Apple for computers or Shell for gasoline. Everybody knows what a shell is, but nobody would think of associating this scallop shell with a gasoline line. I mean, it's like, whoa, okay, this is cool. And so these tend to go through pretty easily too, because foreigners, come on in, bud. Because nobody would think of associating those with the particular goods and services. Now let's go one level down further. You notice we're getting to even lighter green. These are suggestive names. Now a suggestive name is it's kind of arbitrary, but it kind of suggests the quality of the goods or services. So one example here would be Jaguar for cars. Well, you don't associate a big carnivorous cat with a car, but the stereotypical image of a Jaguar is it's a big, powerful, fast animal. And Jaguar, the car company, tries to promote their cars as big, powerful, and fast. So it sort of suggests the quality of the goods. The other example would be Greyhound, where if you look on the side of a Greyhound bus, it shows this sleek, really fast dog running like crazy. And before I was an attorney, I was a professional kayaker, and I rode Greyhound buses a lot because I didn't have any money. Trust me, they're not fast. But anyway, that's what they use to advertise them. And so again, the Greyhound dog and the Greyhound name, it suggests that the bus line is very fast. All these first three are trademarks you're probably going to get. Now let's get down to descriptive names. Now, descriptive names are names that they're not really suggestive because they describe more what you're selling. And descriptive names are often hard to get because you get what's called a mere descriptiveness rejection from the US Patent and Trademark Office. And you notice that the examples of trademark names I put down here that were allowed that are fairly descriptive are all from companies that easily have $500,000 to throw into a trademark battle, and it's not real money to them. When you're starting a business, though, you don't want to you probably don't have $500,000 to put into a trademark battle. So why don't you aim for one or two? Don't get stuck on four. And this is where trademark attorneys and marketing people go head to head, because the trademark attorney says, I don't want to know what you do from your name. And the marketing people say, I have to know what you do from your name. So my suggestion is use a fanciful or arbitrary name and then have a descriptive tagline. So something like Ace Drones, the best real estate photographer around, or something like that. So Ace is kind of in between arbitrary and suggestive. An Ace pilot is a really good pilot. Ace card is a really good card to get. But then you've got your descriptive tagline that describes exactly what you do. Now, the worst type of trademark to file for is a generic one that just describes what you do. So if you're a manufacturer of drones and you call your company Drones, good luck getting a trademark. You ain't getting it. And so you really want to avoid just describing what you do. So if you're a drone real estate photographer and you call yourself Drone Real Estate Photography Services, that's not going to be one you're going to get. Now, the other danger you have is your fanciful mark can become generic overuse. For example, Bayer used to have a trademark on aspirin, but they didn't stop other people from using aspirin to describe pain relievers. Then when I was a kid, when everyone said, oh, go get an aspirin, whether it was a Bayer aspirin, whether it was a Tylenol, the two companies I think have to be very careful right now are Google and Photoshop, because if I tell you, if somebody asks me, where do I find information? Where do I find the USPTO website? I'll say, just Google USPTO. I don't say use one of the readily available search engines to do an internet search on USPTO. And if you've got a picture and you want to make some changes to it, they say, just Photoshop my brother-in-law out. I don't like him anymore. They don't say digitally alter the photograph to remove my brother-in-law. So if I was Google, if I was Photoshop, I'd be very careful about having people trying to turn my trademark into a generic mark. Basics of the trademark application process. This isn't as bad as it looks. So you file the application. After 4 or 5 months, it gets examined, and it either gets accepted and you get a notice of allowance, or it gets rejected. Now, if it gets rejected, you usually have 2 swings of the piñata with the U.S. Patent and Trademark Office examiner arguing why it really shouldn't have been rejected. Now, you may get a final rejection or you may get a notice of allowance. If you get a final rejection, you can appeal, but by the time you've wasted all this time on the final rejection and the appeal money, you're really, really, really going to wish that you had looked a little better at that slide I had a couple slides earlier where it talked about fanciful and arbitrary marks being the best ones. But let's assume you get the notice of allowance. A couple months after you get the notice of allowance, it goes through something called a publication period. Now, a publication period is a 30-day period during which anyone who feels that they'll be damaged by your trademark has the right to oppose it. Hopefully you don't get opposed because oppositions cost a fair chunk of money. And if it doesn't get opposed within 30 days, they give you an issue notification, trademark issues, and then you have to remember to file your renewals. And you have to renew a trademark between the 5th and 6th year, and then year 9, 19, 29, 39, et cetera. It's also important to remember between the 5th and 6th year to make sure you file for the declaration of incontestability, which means that unless they prove fraud or something horrible like that, that nobody can really challenge your trademark. All right. All right, what if you get a final rejection? You get a final rejection, usually you didn't do a trademark search in the first place. If you get a final rejection, and I'm always amazed at I always say I can teach people the law, but I can't teach them to think. You'd be surprised how many people get a final rejection and they just keep using the name. The problem with that is that the U.S. Patent and Trademark Office examiner in his or her final rejection will basically reject your trademark on the grounds that it may confuse the consumer. And they essentially put in writing the case that you need to make when you're trying to claim that somebody's infringed your trademark. So if you get a final rejection, stop using the name. You probably, if you had any questions about it, you should have first had a trademark search done. Second of all, you should have filed what's called intend to use, where you're not using the mark in commerce quite yet. And it gives you a little backdoor way to back out of it without getting sued for trademark infringement. You may also want to consider asking for a letter of consent. Now, letter of consent is from the trademark holder of the trademark you got rejected over. And so you can say, hey, we're kind of in different categories. You're selling, you're selling surfboards for the ocean. I'm selling life jackets for canoe paddling on fresh water. We really don't overlap. Would you mind giving me a letter of consent? And sometimes the other side will say, yeah, sure. And then you write a letter of consent saying, I know about this other application. It's okay with me. We'll do our best to make sure we're not confusing the consumer. The person who got rejected, they've agreed to put on their website. They're not me, they're this other company. This can go either way. We've gotten letters of consent sometimes. Sometimes though, you're alerting the other side to what you're doing. They may not be monitoring the U.S. Patent and Trademark Office database. They may not know that you're infringing their trademarks. So you may have alerted somebody to what's going on. Also, people usually ask for some money. If you get a letter of consent, they usually say, well, you pay my lawyer to draft it, and I want a couple $1,000 on the side as well. So letter of consent is a way you can try to get around that. All right, this is taken from an actual final rejection. And so this is, if you're suing somebody for trademark infringement, this is the best evidence you can have, because the USPTO, U.S. Patent and Trademark Office examiner says, we are refusing you because of the likelihood of confusion with this other trademark. And it's likely that a potential consumer would be confused, mistaken, or deceived as to the source of goods. And so what they're basically saying is, applicant, your mark is way too close to this other mark. And if we were to allow your mark, the consumers would be confused. And so all you need to do if you're trying to make a case here is come up with some examples of consumer confusion. If the person continues to use the mark, it's like, I don't know what we can do for you. Probably not much. Okay, how to get started. This is the last slide I have, and I'll be glad to turn it open to questions or whatever Desi and Kim want to do here. How to get started. And hopefully most of you are at the stage in your business where it's not going to be the end of the world if you have to go back and change your name or add a fanciful or arbitrary name above the descriptive phrase that describes your goods. So reread my page on what makes for a good trademark search. Second of all, you can do your own trademark search, www.uspto.gov, US Patent and Trademark Office, and then you go to Trademark, search trademarks. Just like doing a prior art search where you look for potential patents that may get in the way of you getting a patent, this is not the easiest thing in the world. So I always, always, always recommend, after you've looked, if you haven't found anything close, get a professional trademark search. As a matter of fact, I think that the company in India that they do all of our prior art searches, they do our trademark searches, they do our patent illustrations. I think that both of them are actually on right now. So Ram and DeGamber, if you guys can throw your contact information on there. I don't do it myself. Don't hire a patent attorney to do a trademark search, because there's no way that with what they charge, there's no way that in, I guess it'd be 50 minutes, I can do on an hourly rate what they can do in as long as it takes them. And always, 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 the professional search costs way less than the actual application does. So you might want to, I mean, let's take utility patents, for example. I charge a flat about $8,000 for those. The average prior art search costs $800. So why don't you pay the $800 to see if you really want to pay the $8,000? So after you've done your own search, after you've had a professional search done, look at the search results. If you have any doubt about how to proceed, the safest way to proceed is something called 1B intent to use. You can actually have your trademark application on a federal level filed where you're not using it in commerce. It's called an intent to use. You're saying, I'd like to use this mark in commerce, but I don't know if I'm going to get it, so I'm not using it yet. And this is where people who do these online trademark filings, where for, quickie trademarkfilings.com for $99 plus the US Patent and Trademark Office fee, get in trouble because they don't do the search there. And so if you're like the dumbest drone flyer in the world and you decide that you're going to call your drone photography services Microsoft Amazon drone photography services, yep, that's what I'm going to do. Well, you do it online, they're going to say, okay, just pay us the money, and they'll click it. And they'll say, do you want to do it in use or intend to use? And you file in use. Well, you've just put in the record that you're using a trademark that is going to make Billy Gates and Jeffy Bezos very unhappy with you. And you've already put in the public record that you're using it in commerce. You've just made their case for trademark infringement. So when in doubt, file under intend to use. Okay. All right. So that concludes the material that I wanted to present. Desi and Kim, how do you want to do the rest of this?
Well, first of all, thank you. Great information. Yes.
No
Yes,
problem.
that was awesome. Yeah.
And so I posted your information again into the chat. I also did get a link to the Women in Drones library that offers that information that you were referring to in there.
Sure.
We do have a couple people that have made some comments, and Kim, if you're okay with it, I'd like to see if anybody has any Q&A that they'd like to kind of ask Eric.
Yeah, I think that's a great idea because, I mean, this is something that we're all being presented with right now because we're all, a lot of us are just starting our businesses or have only had it for a few years. So yeah, good, man.
Yeah, this is a good time to get those questions answered at the beginning, because I'd hate to see a bunch of you go crying off the Women in Drones presentation 15 years from now when you find out that Microsoft Amazon drone photography services just got hit with 2 trademark infringement lawsuits. Yeah. Now, Desi, I can't see the chat right now.
Okay.
Let's see.
Well,
here.
when you stop sharing your screen, you'll probably get the rest of.
Okay, that sounds like a really good way to do it.
There is a comment from John Winslow, and he says the DeGamber that you recommended was the best money ever spent.
Oh,
He was faced with over 40,000 similar names, and it took me hours to get through the first 400. I gave it over to DeGamber, and he got it done in a week.
Wow.
So
Okay, good.
great testimony. Thank you so much, John.
Yes,
Okay.
yes.
So that was besides the money I spent for Eric. He was well.
Yeah, right.
Not spelled
Literally,
with me, he spelled it to Jamber. I know that, but
Well, when Eric was saying it, I apologize, but I met Eric through firsthand experience when my original product got stolen, and I took one of his previous classes, and I talked to him, and everybody had the same story. So if I can just add in, if you have an idea at all, get it safeguarded, because people will steal it.
That's right. Yeah.
And Eric was able to do a design patent for me where another attorney wanted $10,000 to $15,000 to do it, and Eric did it for a fraction, and it was, I mean, it was, like I said, a fraction of what this other guy wanted, and it was the best thing I ever did. So please do it so you don't end up like me.
And there's so much more involved than
Right.
you think. It's deep, and so it's like, where do you even begin? You know, so good information.
yeah. The other thing that I would encourage is to talk to other people. I mean, John brings up a really good point. A lot of the people that have come to my office have come in after a really bad first experience. And, you know, they've either been ripped off by an invention promotion company, they've had somebody steal their idea, they've had bad experiences. So talk to other people. I mean, there's no right and wrong answer here, but there's an awful lot of free information out there. Oh, by the way, if Sharon is putting on a couple of articles I've written on the patent application process, the trademark application process, and I think that they're actually putting this PowerPoint on the link too. Feel free to download it. If you can't download it, email me and I'll be glad to send you. We call it the kitchen sink. So if you ask for the kitchen sink, I'll send you the kitchen sink, and hopefully some of it will prove useful to you.
Hey, Eric, it's up now. It's on the website now in the
Okay,
library.
great.
Desi's put the link out there for everyone. So thank you so much for providing that for us.
No problem. Okay, Moss.
Vic,
You've
Vic
all
has-
right. Vic Moss has a question here. Moss Photography trademarked in Colorado for 10 years. Should I really search for a national trademark? So Vic, why don't you unmute yourself, because you ask a good question here. So if you've got Moss Photography trademarked in Colorado, would you like to expand beyond Colorado? Because if so, I'd suggest that you do search for Moss Photography on the federal level, just to keep somebody else from grabbing it and trying to geographically limit you to Colorado. The other thing too is when you submit your application, be sure to remember that you're going to need a consent to use name, because you're using your last name. I actually did a trademark presentation for one of the local chambers of commerce about 8 years ago, and they said that the attention span was not great in this group, so I had to come up with a catchy slogan. And so my trademark speech was entitled, "What do Tim Tebow, Colin Kaepernick, and Honey Boo Boo have in common?" And the answer was that none of their attorneys remembered to put in the consent to use names. So if you look at Tim Tebow's trademark application, this is live. I mean, the thing about being a patent or trademark attorney, everything you do is public record. So if you screw up, man, it's there forever for people to look at. So Tim Tebow's attorney, which was a big hot shot, of course, huge New York law firm, they submitted the trademark application. They got a rejection, and they said, "We think you're trying to impersonate the famous football player, Tim Tebow, so we're rejecting you." So then they had to come back with a response where Tim Tebow said, I really am Tim Tebow, the famous football player, and I consent to use my name. And so apparently Tebow and Kaepernick, like, they didn't talk on the field about trademarks, because Colin Kaepernick made the same mistake. And so he had, I really am Colin Kaepernick, it's okay to use my name. Then Honey Boo Boo made the same mistake too. But the Honey Boo Boo is a little more interesting issue, because Honey Boo Boo is like 6 years old when her parents had the law firm file on behalf of, these are like, big, huge Beverly Hills law firms. It's like, God, don't you guys know anything? And so they didn't put in the consent to use her name. And so then the issue became the entire program was built on the incompetence of the family. So were the parents competent to consent to use this little girl's name in trademarks? I mean, that was a good question. But anyway, they all fixed it sooner or later. But yeah, Vic Moss, consent to use name.
Well, do I plan on you? I mean, I already have clients across the country, actually international.
I would, Vic.
I'm never going to leave. I'm not going to franchise myself. That'd be kind of an interesting physics exercise. But I have clients all over the place, but I'm not going to leave Colorado. And it's actually, my typo is over 10 years, not 10 years. That doesn't make sense. But I did a quick search actually on USPTO
Yes.
as you were talking, and it's not, the phrase Moss photography is not trademarked as of now.
Then Vic, do another one. Get into that same advanced search and type in Moss, capital AND photo, and see what you get.
Okay.
Because that'll look for everything that has Moss and photo. And then if you do a structured search, you can look Moss as the name of the mark and photography as the goods and services.
I'll do that.
Okay. Hopefully you don't start screaming online because you find bad
No. I'll wait till we're done.
Yeah. Okay. But yeah, it's worth doing. And again, when you sell a business, your goodwill is hopefully what you sell with the business. And if
I'll probably never sell either, because like I said, it's me. So,
but don't you want to make some money off it at the end?
No, not really, because I'm me. I mean, people hire me; they don't hire my company. So yeah, it'd be an interesting. I can figure out how to do it. Yeah, I'll do that.
Well, I mean, I sold my kayak school for a nice chunk of money, and went off and became an attorney. I don't know if that was necessarily the happiest move I've ever made in my life, but it was the body was beginning to break down, so it was time to do something where I could sit instead of having to paddle all day for a living.
So Eric, what does happen when you have a company and then you sell it with your name?
Well, you do something called it's all part of the package. Mm-hmm. And so if you wanted to sell a drone photography business, you had a trademark name, you'd do something called an assignment of the trademark. It's very, very easy to do. You do that as part of the sale of the business. And you could sell your business through a business broker, or you could just sell it online directly. For most of you, I would, the neat thing about the drone industry is we're just starting out here. I mean, I consider myself one of the more senior pilots because I started with a Phantom II, and that was like 7 years ago. And so we all have the opportunity to really turn this into something. And I would urge all of you to not forget about franchising. Subway makes a ton of money, and basically they have an instruction manual and they have a trademark. It's like, you buy the use of their name in this territory. They come in and they train you how to do it. And then, they get a residual from every one of their branches. So franchising is something that I'd urge all of you to at least keep in the back of your mind. And then eventually, and again, if you really want the kitchen sink, I teach a 6-hour class on intellectual property at colleges. I can send you that whole thing too. It's a beast. The PowerPoint is like 7 megs. So, check your junk mail because it probably will end up there. But the last thing I say is that when you're starting a business, plan on the end game. What do you want at the end? Do you want to give it to your kids? Do you want to sell it? How many years do you want to work in this? How many years will you be enthusiastic about this? I mean, I know with my kayak business, I was sitting on the beach on the Napoli coast of Kauai, which is probably one of those beautiful locations in the world. And I was sitting there and I was realizing that my shoulder hurts, my back hurts. I don't ever want to have responsibility for a group of 6 people on a kayak trip again. I realized, okay, I need to sell this business while it's still worth some money. And so sooner or later, maybe you'll get to that point. So let's start planning the exit strategy now. All right.
Let's see. Begin with the end in mind.
Okay. Oh, Daniel Strand. Oh, Daniel. Hey, Daniel. Good to see you. Cost in trademarking one term and how someone goes up picking which trademark classification they choose in filing. Sure. Trademarking one term, I would consider that after you have the trademark search done. In terms of classification, if you go through a trademark attorney, the trademark attorney will hopefully give you the good advice on what to file for. If you want to try it yourself, there's something called the Goods and Services Manual that has, it's like, I don't know, 3,000 pages of goods and services. All trademarks are classified within one of 45 different classes. And there's actually trademarks cover goods, service marks cover services, but they're all lumped together as trademarks. So you have to kind of pick the category naturally by what you're selling. So if you're selling clothing, you're going to find that it keeps directing you into class 25. If you have a website, it's going to keep pushing you into 41 or 35. And so you'll kind of get pushed in there naturally, but if you're going to try this on your own, do the picking on your own. Don't go through one of these online services because they will probably send you in the wrong direction. And I make an awful lot of money charging hourly to try to fix the problems. And in fewer than 10% of the cases, does the person pay me less to try to fix the problem than they would have paid me to file the trademark in the first place. So pick your own categories and learn what they are. Let's see.
Well, again, great information. And I can just see Kim's wheels turning because I know
Oh, yeah.
big picture. And so
Oh.
I know she's thinking.
All about the big picture. Hey,
But-
Jim, that's the way we roll, right, Jim?
By the way,
Go big or go home.
Yep.
I virtually lived what Eric was talking about because
I was thinking that.
Radio Control Specialties was bought by High Tech.
Right.
So I
Yep.
literally did sell my company. Yes. All of those things were fantastic points in making sure that you are getting your proper valuation and what you're truly bringing.
but by the way, I practice what I preach.
Okay.
Everybody see that?
Yes, we see it.
A whole bunch of drone zone trademarks.
Oh, yeah.
Those are all owned by me. And a lot of them are incontestable.
Have we heard of the drone zone before?
Yeah, I gave away a shirt a couple of days ago.
Yeah,
If
I
they have
understand it's
permission
kind
to
of
use it.
yeah, I do have permission.
I'm waiting until a few more of these become incontestable. And then some of the people who like to go around saying no drone zone, we're going to have some discussions after that, but it has to become incontestable first before I start rattling my saber at all.
So Eric, on that, it just reminds me of a battle that went on several years ago in New Jersey with a company that I, have talked with, both done some stuff with both of them. One is New Jersey Drone Zone, and the other is Drone Zone New Jersey. So let me just throw that out to you. How does that work?
What I'd say there is if they can get a federal trademark on drone zone, I'll be glad to leave them alone.
Okay.
Until then, they're infringing my trademark and they should be writing me for a letter of consent.
Ah,
And it's not going to be free.
right.
Yeah.
I would hope
I
not.
like it.
No. Yeah. And there's a whole lot of trademark infringement going on out there. If any of you really want to get in a bad mood, do you all know how to do, I guess this is another class, but you all know how to do Google search for people who are ripping off your images?
No.
Okay. I can go over that sometime. Well, Jim's nodding his head. You basically get on Google search, you upload one of your images and it finds everybody on the internet who's stealing it. And I was doing, back before COVID, I was doing a class for I think it was the SD droners here in in San Diego County, and they're all in my office. I said, here, let me just show you how we do this. So I pulled up one of my images, and by the time I got to like the 15th person who was stealing it, I was so angry. I just going, I can't believe you people are doing this. And so do it sometime when you're by yourself. No one's listening to what you say, but you're not going to be happy. And you find out all sorts of things. I found out that DJI took one of my pictures, put it on their webpage. It was just like, that's cool, but could you guys have told me maybe? I mean,
So that brings up a really good point that maybe sometime we should maybe offer something where people can learn how to search for their images and protect themselves for what might be putting out there. Because I know everybody puts things.
You know,
onto
I would
social media.
also add that as a drone professional, where imaging is part of what we do. That's an essential skill. I've literally had to send cease and desist orders to students of mine who have taken images from my website and put it on theirs. So, you know, it happens. But you know, and Eric, you can attest to this. This is a skill you should have on the outside of your work, because you might get a picture of someone, or you might get an image sent to you of someone that's soliciting something. Do a quick image search on that image and find out how many other millions of people are ripping that image off, and you know instantly it's a scam.
Yeah. I just held up my two most recent copyrights. But yeah, after I come back from a trip, and again, I come back from a trip, I'll usually copyright what I think are going to be my 10 or 20 best images from it. Yeah, I'd be more than happy to put on another one of these on how to do a Google image search. And when you're looking at intellectual property, to file your own patent is very difficult. I mean, we go through, to become a patent attorney, you got to have an undergraduate degree in the sciences. You got to pass the state bar. You got to pass the patent bar. You know, you got to go to law school. Trademarks, about 1 in 3 people get it right, but the people who get it wrong screw up pretty badly. Copyrights, if you go through this class that I can put on, everyone should be able to do their own copyrights. And it's really worth doing, because again, you know, I refuse to go to court. I actually got dressed up for you folks today by wearing a t-shirt without holes in it. But, you know, again, we settled a couple of cases for $60,000 plus for minimal copyright infringement. And if you don't have a registered copyright, good luck getting any money out of anyone.
All right, well, with that, we need to wrap up, and there's a yes, please. We'd like to have that class. So maybe we can think about that moving forward to 2021. Eric, thank you so much. Great information. I know it's something we all need to really think about, and we don't. Yes, on the copyright class. We've got another one popping in there. So thank you so much. I think we're going to leave you with one little tidbit. This is our last meeting, except for what? What, Kim? What are we doing?
A holiday party.